Hi, I'll get started then. This final talk of the day is on third country cases. I'm Harriet Short. I'm a member of the One Pump Court immigration team, and myself and Ben Bundock are going to be taking you through the consequences of Brexit on third country cases, both in terms of requests to the United Kingdom and the position of applicants who are in the United Kingdom already. I'm going to start with a brief overview of the Dublin III regulation, which is part of the common European asylum system, of which the UK will cease to be a part at the end of transition. I'll spend about 5 minutes just recapping on that. Then I'll talk about what the government sought in the negotiations. Then Ben will look at the exit regs. Then I'll look at the future of third country removals and consider some case studies, some examples of cases we're likely to see in our practices. And then finally, Ben will look at options for transfer to the UK. So moving on to the first slide, Regulation 604 of 2013 is known as the Dublin Regulation. Its purpose is to ensure that an asylum application is only considered by one of the participating Dublin states, and those are the EU member states, plus Iceland, Norway, Liechtenstein, and Switzerland. The Dublin Regulation and the Eurodac database were intended to prevent forum shopping. That's asylum seekers lodging multiple claims in different member states, and also to prevent refugees in orbit. That's where no state takes responsibility for an asylum claim. The practical application of the Dublin Regulation is underpinned by the Eurodac database. That's an EU-wide database used to store, transmit, and cross-check fingerprints taken from applicants for asylum. By cross-checking fingerprints across the database, Dublin states can see whether a person has already irregularly entered or made an asylum application in another participating state. The UK will cease to have access to the Eurodac database, and the Dublin III regulation will cease to apply to the UK after the end of the Brexit transition period at the end of this year. What's in the regulation? It sets out a process for handling requests to transfer responsibilities between participating states. It gives procedural rights and time limits. And in Chapter 3, Chapter 3 gives a series of criteria which are applied hierarchically from Article 8 to Article 15 in order to determine which member state is responsible for determining an asylum application. The first few criteria in the hierarchy are underpinned by a focus on the best interests of children and ensuring family unity. If people have family members in other states, the regulation provides that those states are responsible rather than the first state through which the applicant passes when they come into the territory of the EU. Now, just broadly, Article 8 applies to unaccompanied children who have family members or relatives legally present. Article 9 is broadly people in a member state who have family members in the UK, and so on. And in very brief compass, how this has worked in practice, like Nina's example in the panel discussion, is that if you have, for example, an unaccompanied child who's crossed a border into one Dublin state, for example, Greece, but they have an uncle in a second Dublin state, here the UK, Greece can ask the UK to take charge of the applicant's asylum application because family member for a minor is higher up the hierarchy. And you can see that having passed through a safe third country, having crossed a border irregularly, Article 13, is quite low on the list of criteria. Now, once responsibility is determined according to the hierarchy, the obligations of the member state are set out in Article 18, and they require the member state to take charge of an applicant who's applied in a different member state, and that's 18.1a or 18.1b, c, d, to take back if there's already an application in another member state. To give an example, if an applicant has crossed a border irregularly, for example, arriving by boat to Italy and then travels to a second member state, for example, the UK can ask Italy to take charge under 18.1a if they've entered Italy irregularly, or they can ask Italy to take back the applicant under 18(1)(b) if the application for asylum is already being examined in Italy. The legal framework for the operation of the Dublin regulation under our domestic law is the certification provisions set out in Schedule 3 of the Asylum and Immigration Treatment of Claimants Act 2004. And again, briefly, a person arrives and makes a claim for asylum. Usually the United Kingdom would have to consider that application. However, under Schedule 3 of the 2004 Act, the Secretary of State can issue a third country certificate preventing that asylum claim from being considered. If that person then makes a human rights claim, says, no, you can't remove me to this safe third country because my human rights would be breached in Greece or in Italy, the Secretary of State for the Home Department has the power under the same schedule to certify the human rights claim as clearly unfounded. Clearly unfounded certification has to be challenged by judicial review in the courts. It deprives the applicant of a right to appeal to the first tier tribunal. The tests are familiar, is whether the claim is bound to fail, whether the claim has no prospect of success, that's AK Sri Lanka. In EM, Eritrea, the Supreme Court delivered what remains the leading case on third country removals. They confirmed the Suring test is applicable in the Dublin context, and they held in terms that an applicant did not have to demonstrate a systemic deficiency in order for a potential removal to give rise to a breach of Article 3. So how has the UK used the Dublin regulation? Well, as an island in the north of Europe, it made significantly more requests to transfer out of the UK than requests it received. And you can see in these figures taken from the government's immigration statistics that there were 2,226 requests to transfer in, 714 actual transfers in, the majority are from Greece. There were 3,258 requests out and only 263 actual transfers out. Notwithstanding the considerable benefits enjoyed by the United Kingdom and the inequities of burden sharing around member states, the Dublin regulation has been a source of consternation because it prevented the UK from detaining asylum seekers indefinitely and set time limits for transfers. So what did the UK seek in the Brexit negotiations? Well, in its February 2020 paper on the future relationship, the UK expressed its intention to seek an agreement to continue to be able to transfer asylum seekers. Then, in May 2020, the UK proposed a UK-EU readmissions agreement. This sought obligations on either side to accept the return of citizens and certain categories of non-nationals irregularly residing in each other's territory. This agreement had a broader scope and a different purpose to the United Kingdom. Rather than being concerned with assigning responsibility for a person's asylum claim, it sought to establish here effective and swift procedure for the identification and safe and orderly returns. And it lacked, in particular, time limits and procedural protections. Very briefly, Article 6 of the proposed agreement provided that an EU member state would be obliged to readmit all third country or stateless persons who don't qualify for entry, presence or residence if the person, for example, had a valid visa or illegally and directly entered the UK after having stayed on or transited through the territory of the member state. Identical obligations for the UK to readmit were set out in Article 4. Well, that was how it started. Now, how is it going? There's very little formal indication of the progress made in negotiations so far. And if you just move on to the next slide, there are reports that the UK has rejected the UK's proposed agreements because they're beyond the scope of their negotiating mandate. Neither the political declaration nor the EU's draft text for a new partnership agreement with the UK specifically identify asylum, unaccompanied children or readmissions or as areas for future agreement or cooperation. And so, as you can see from this report, the reports say these proposals were rejected in August. So what will happen after the end of transition? Well, I can't take you to any agreements, as you've seen, because there are none. So let's look at what the authorities are saying. In September 2020, the Home Affairs Committee pressed high-ranking Home Office officials to confirm what would be the default legal position on returning third country nationals to EU countries after the 31st of December 2020. This is just a couple of months ago, and I think it's fair to say that the officials were unable to provide immediate clarity. The chair asked Tyson Heppel, now he's the Director General of Immigration Enforcement for the Home Office, and he asked whether there's any legal basis for third country returns from January 2021. And here you can see Mr. Heppel's non-answer. He was pressed on whether under existing international law, the UK authorities will have any legal abilities to return people to other countries, yes or no. Again, the Director General of Immigration Enforcement in September had no idea. The chair's attention turns to Abby Tierney, who is the Director General of UK Visas and Immigration, and again, no idea. And in case you thought that the Home Office might really want to know who they can expel from the United Kingdom after Brexit, we've got here at the next slide, Dan Mahoney, who is here's the title, Clandestine Channel Threat Commander for the Home Office. He's asked whether they're doing any contingency planning, and don't worry, they want to start that conversation soon. Going back to Mr. Heppel, he's not aware of any immigration rules on safe third country provisions, and I'm going to take you to those shortly. Following this session in September, Ms. Tierney and Mr. Heppel followed up these questions with written evidence from the Home Office. In their evidence, they noted the sincere offer to the EU regarding readmission, which I think must be a reference to the draft working text that I've taken you to. And they recite what they seem to be shaping as the customary rule of the safe third country concept. And they refer to the immigration rules, which I'll take you to in detail in a moment. But to summarise, as of November 2020, there was no agreement for outstanding Dublin transfers at the end of the transition period. Now, you may be aware that there are exit regs which relate to Dublin. These are going to be explained by Ben in detail very shortly, and close your ears now if you don't want the spoiler, because these only cover incoming cases, requests for transfer to the United Kingdom, and they cover cases where a request has been made but not decided before 31st of December. So they don't cover applicants who are in the United Kingdom who the UK might want to transfer back to Italy, Germany, France, and so on. So with that smooth segue, I'm going to pass over to Ben.
Hi, so hopefully you can hear me okay now. Just briefly before I go on to talk about the transitional provisions, just to flag up this Section 3 of the Immigration, Social Security Coordination EU Withdrawal Act 2020. Because during all of this process that Harriet's been describing, there were efforts made around Parliament by Safe Passage UK and other organisations to try to preserve legal routes to the UK for protection claimants. And obviously, as you've heard, those efforts weren't successful, but they did result in this Section 3, and you'll see what it says here. In summary, I don't think this is anything to get your hopes up about. But what it provides is that the Secretary of State must review the ways in which protection claimants in member states are able to enter the UK unlawfully. In particular, there's an obligation to consider the position of unaccompanied children and to have a public consultation on that aspect. So obviously I wouldn't hold your breath, but that public consultation will be forthcoming, and you might want to keep an eye out for that if you do work in this area. And so then on to what has been brought into law, the transitional provisions within what I'll refer to as the exit regs. I know that there are a lot of exit regs, but for today's purposes, that's the shorthand I'll use. So the general position is that Dublin 3 is revoked in domestic law, along with the implementing regulation and the Eurodac regulation, which Harriet referred to earlier. That is with specific specific savings and transitional provisions, but as Harriet has already said, only in relation to take charge requests made to the UK. So there are no transitional provisions relating to removals. And so it's only what I'll call incoming cases, and it's only those cases where there is a request made to the UK before the 31st of December, but no decision is made before that date. And so these provisions deal with really a very narrow set of cases. For that reason, I don't intend to spend a great deal of time on them today in my presentation. The slides contain quite a lot more detail than I'll give orally, so that if you do have one of these cases, you can obviously come back to these and see if there's anything useful in there for you. But for today's purposes, I'll keep it rather more brief. And so in overview, some provisions of Dublin 3, not all of them, will continue to have effect for some types of incoming case where the request's been made before New Year, but no final decision. So now I'll explain which provisions and which types of case. The types of case that are covered are what are called, are those which are covered by what are called the Dublin family provisions, and the clues in the name. The definition is there in paragraph 9.8 of the exit regulations, and it's the provisions on unaccompanied minors, family members, meaning spouses, minor children, parents of minors who are beneficiaries of international protection, then articles 10, 11, 16, 17 to, I won't cover all of those in detail. If you practice in these areas, you're likely to be familiar with the scope of these provisions. So those are the cases that are covered. The ones that aren't include those where the UK is or might be responsible under Article 3.2 or Article 13, which would be, for instance, if someone has passed through the UK onto another member state and that member state is trying to return them to the UK because they came through the United Kingdom first and made a protection application. So those aren't covered by these provisions, it's just family cases. Which provisions are saved? And when it comes to Dublin 3, it's really just the very bare bones. So Article 2, the definitions, which obviously is essential. Article 6, the guarantees for minors, very important, including the express requirement that the best interests of the child shall be a primary consideration or decision making. And then Articles 22 and 25, which just provide that there's an obligation to make a decision on a take charge or take back request within the specified time limits. Then also preserved are some important articles of the implementing regulation. And these really are what give bite to the provisions. Because Articles 3 and 4 of that regulation are what require the UK, if it, having reviewed all the evidence, decides that it is responsible, shall acknowledge its responsibility. So it's what gives the criteria effect. Article 5 provides that the UK has to give full and detailed reasons for its refusal, and Article 6 that if it's a positive decision, then that has to be accompanied by the practical details and arrangements for how the requesting member state can effect transfer. So that's what's been saved for these cases that come in before the new year but aren't determined before the new year. What the provisions that are not saved, and I've broken these into three categories. The first one is the category that I'll cover in detail. The provisions that I think are likely to be significant and important in these cases. Secondly, some that I think are concerning that they haven't been saved, but I'm not sure they're going to make a difference. And thirdly, provisions that I don't think are going to make a difference for incoming cases. So starting with the important ones, and really there are four here, or four groups of them. And again, there's more detail in the slides than I'm going to give now. First of all, Articles 22.7 of Dublin 3 and Article 12.2 of the implementing regulations, they sort of come together. Because the position currently is that if the UK takes more than 2 months to deal with a take charge request, say from Greece, if they take more than 2 months, then the UK becomes responsible automatically under Dublin 3. That won't be the case any longer for requests that come in before the new year but haven't been made. And so if the UK takes longer than 2 months after the new year, there won't be that default transfer of responsibility. Obviously, that's unhelpful because it means that they can take longer and that there won't be that automatic transfer. What it is likely to mean is that that delay beyond 2 months is likely to be actionable much more quickly than it previously would have been. And there's the case law on this is highlighted in the slides below this one. Second provision, possibly the most significant here, is Article 27 hasn't been saved in relation to these transitional cases, because currently, as you're likely to know, Article 27 provides clients with the express right to an effective remedy in fact and in law, and that's not been saved. As you're likely to be aware, in the authorities that have come out of the Upper Tribunal and Court of Appeal in the last couple of years, Article 27 has had some very far-reaching consequences, because the authorities have established that in these cases where there's a take charge request made to the UK and that's challenged by JR, the court or tribunal effectively steps in as the primary decision maker. They decide whether the criteria has been correctly or incorrectly implemented, decided, and if necessary, they'll make findings of fact and findings on the evidence in order to do so. So this is a far cry from the ordinary judicial review jurisdiction. Article 27 hasn't been preserved for these transitional cases. The upshot of that, I don't think is completely clear at this stage. And for the reasons that I set out in the slides, which you can have a look at later on if you're interested, I think there's going to be a good case that because of the tribunal's human rights jurisdiction, which will almost always be engaged by a take charge request relating to family members, that there's going to be a route for us in JR to directly challenge findings of fact on the evidence if that's what needs to be done. For example, if the Secretary of State doesn't accept that your client is related to the family member, or if they're disputing that it's in the best interests of the child to be transferred to the UK. But that's an important provision which hasn't been preserved. Article 29, currently, say if the UK accepts responsibility, but then the requesting state, again, I'll use the example of Greece, Greece doesn't manage to effect the transfer within 6 months, then responsibility reverts back to Greece because they haven't effected that transfer quickly enough. And that hasn't been preserved, so that won't be the position in relation to these transitional cases. Fourthly, Article 5.2 of the implementing regulation. And this expressly provides that, again, say Greece, if there's a first refusal from the UK, Greece can ask for them to look at it again, and they can submit further evidence or just make observations and arguments. And within the framework of Dublin 3, the UK has to re-examine the matter, and that's gone. So it looks to be, under these saved provisions for this class of transitional case, that the first decision is the final decision and the one that will have to be challenged by JR. Anything that follows in terms of back and forth between the member states looks to me to fall outside of these provisions. So that's a sort of whistle stop of the important provisions as I see them, and you're about to see me flash through the slides where I give a bit more detail, which again you can have a look at later on. So second category of provisions that haven't been preserved, which I think are concerning, are these ones. But again, as I said earlier, I'm not sure in the end these will make a difference, and I hope that they won't. But I flag them so that if you do have a case like this falling under these provisions, you can come back and use this as a starting point or a guide. And then finally, long list of provisions that I don't think will make a difference in this type of case, mostly because they really relate to the position where the UK is the one that's trying to send someone to another country. So finally, just briefly to end with some practical thoughts and considerations. And those of you who deal with these type of cases or have dealt with them already probably know much better than I do the practical realities of preparing them and dealing with the requesting member state and so on and so forth. But these are just some observations and thoughts that I had going through the regulations as to things that might be worth keeping an eye out for or or having a look at. So first thing is, if in the next month you happen to become involved in another one of these cases, and it's at the early stage before there's been a request or before there's been a decision, first decision from the UK, do whatever you can to get the relevant evidence together and put it to the requesting member states so that they put it to the UK. I would do that as fast as you can, and certainly before the end of the year. Again, if you're involved at this early stage, do whatever you can to get the requesting member state to put that take charge request in before the end of the year. Obviously, ultimately outside of our control, but crucially important, because if it doesn't go in before the end of the year, then it's not going to be covered by Dublin, as I understand the position. As I said earlier, it's crucial to challenge that first negative decision that comes after the new year, because any further decision making, it seems to me fairly clear that it's going to fall outside of these provisions. And so I'm not quite sure, without thinking about it in a lot of detail, what kind of legal territory you'd be in. But certainly you wouldn't be challenging on the basis of misapplication of Dublin, or at least that's how it seems to me. In any challenge, and this is existing judicial reviews which are ongoing, or any judicial reviews that arise from the transitional provisions in that interim class of case. And this is what Nina was talking about in the panel discussion earlier, of how important it is to think about the mechanics of what's going to happen and how to make sure that we get the outcome that we need for the client. Because any further take charge request that's made, say under Article 17.2 after the new year, that's going to fall totally outside of Dublin. And so if a JR is withdrawn now on the basis that that's going to be done and that will trigger another decision, on the face of these regulations, it would fall outside of them. Even if they fell within the regulations, because the decision isn't made before the new year, then they'd be subject to these more limited saved provisions, which could well be disadvantageous, particularly in relation to the nature of the remedy, given the removal of Article 27. So that all just has to be given careful thought in my view. Obviously, in any JR that's issued under these transitional provisions, it's going to be important to think about the arguments that are brought about the scope and intensity of review, to try to preserve that more searching, more intense review that's been established under Dublin 3. And finally, that if after the new year the Secretary of State's taking longer than 2 months to make the decision, then that's likely to be challengeable by JR, and you could proceed with that. In my view, it looks like you could proceed with that very quickly and confidently to get a decision. So that concludes my sort of whistle-stop tour of those regulations, and I'll just now hand back over to Harriet to talk about the next class of case.
Unmuted, thank you. I'm now going to look at the possibilities for transfer if your client is still in the United Kingdom on the 1st of January 2021. Very recently, The Telegraph has, this is in September, reported a source saying that a post-Brexit system will reject claims as inadmissible if a person should have claimed asylum in the first country they entered. I think The Telegraph is referring to the immigration rules, which are on the website, and they don't need an anonymous source. Let me take you to the immigration rules. On 1st of October 2019, changes to the safe third country and inadmissibility provisions of the immigration rules were introduced. 345A and AA will not apply after the end of transition. They cover while the UK is a member and while the UK is otherwise subject to the Dublin regulation. They won't apply after the end of transition. 345AB, thank you, Ben, provides that where the Dublin regulation no longer applies to the United Kingdom, save for the exit regs that Ben has taken you to, paragraph 345AC applies instead. Paragraph 345 AC, this is only part of it, but the parts that are relevant to us now provides that an asylum claim may be declared inadmissible and not substantively considered if the Secretary of State determines that another country is either the first country of asylum or another country is considered to be a safe third country. Going over now to 345B, that defines first country of asylum, and either a person is recognised as a refugee or other type of protection, or they have made an application for asylum, or they could have, but there were no exceptional circumstances. And I just want to draw your attention now to 345 Roman 4. The applicant will be readmitted. I'll talk a bit more about that in a second. 345C defines a safe third country as distinct from country of first asylum. That is a country where a person won't face threats to their life or freedom on account of a convention reason. They won't be refooled, they won't be subject to Article 3 ill treatment, they can request refugee status, and also that there has to be, obviously that could apply to many countries, but also there has to be a degree of connection, and importantly, I'm going to highlight subparagraph 6, the applicant will be admitted. Now, these safe third country criteria, and 345D provides some additional consideration for the connectivity requirement that you saw earlier in 345C Roman 5. So the safe third country criteria under the immigration rules are different to the Dublin regulation. There's no provision akin to Article 13 in the Dublin regulation to return someone simply on the basis that they've passed through. Rather, there has to be a safe third country is a country that will offer you protection in respect of non-refoulement and where you have a sufficient connection, and really importantly, where you will be admitted. Both 345B and 345C have a requirement that the person will be admitted, and that obviously requires an agreement, and that's why a regulation like Dublin is so important. Just to add on, 345E is the Dublin rule, which will no longer apply. I just wanted to show you it because it's going to be relevant later. The accompanying policy, which is still on the website, was published on the same day as the statement of changes, and it doesn't reflect rules 345AA to 345AC. But it does provide that unless there are specific agreements in place with a country, removing a third country national must be attempted on a case-by-case basis. Each case must be looked at on its own facts. Now, as you're no doubt familiar with third country removal cases, as I took you to, Schedule 3 of the 2004 Act deprives an applicant of their right of appeal to the first tier tribunal. This is the same with these inadmissibility provisions under the immigration rules. Certification will either completely remove the appeal right or make the appeal right exercisable from outside the UK. So challenge to these provisions is by way of judicial review. This isn't new. If we move on to the next slide, there's a case called RR Syria, which dates from 2010. You might remember Mr. Heppel, him saying that we don't move to non-EU countries, but there is case law on this. In RR Syria, RR was a national of Syria married to a national of Algeria. They had 3 children. Secretary of State made a decision to remove her from the United Kingdom and intended to remove her to either Syria or Algeria. And Algeria was identified as a removal direction because of the claimant's links with that country. She was married to an Algerian national. She had Algerian children, and she had lived there for some 9 months prior to flying to the UK. The UT held the fact that an individual is a refugee, has a well-founded fear of persecution in their country, that doesn't automatically entitle them to a grant of refugee status. Article 33 of the 1951 Convention only prevents refoulement if the country of destination is one in which the individual's life or freedom would be threatened. In the event, in Syria, the UT found there was a risk of chain refoulement from Algeria to Syria and a risk of Article 3 in ill treatment. But there exists in the rules and in case law the possibility, and I think we're going to see greater use of these provisions. What are the issues with these provisions? How do they compare? Well, one of the most significant omissions is that there's no access to the Eurodac database. So there's much less opportunity to discover previous applications. There's no dates attached to a person's chronological narrative, as opposed to the dated stamp with match on the Eurodac database. And really importantly, there are no guarantees of admission, which the cooperation under the Dublin III regulation provided for. This is from the Home Office policy. It's clear that admission is a practical requirement and it's an explicit legal requirement of the immigration rules. That said, the immigration rules at 345 have no procedural protections. They have no right to information, no requirement for a compliant interview, no time limits, no detention time limits. What else can we expect to see? Well, the 2004 also provides for failure to claim asylum to be irrelevant in a third country as a relevant factor in credibility. And so I think we will see, now these people aren't removable to third countries, enthusiastic use of Section 8 factors. Obviously, credibility is often key to asylum claims. What else might we see? Well, this is outside the scope of my practice and further to the blue sky thinking on wave machines, but UK and France have made an agreement for tighter border enforcement. How might these things work in practice? Well, I've tried to think of work through some common examples. Let's start with the example of Mr. M. So Germany accepted Mr. M in July, and on the 1st of January, Mr. M is still in the United Kingdom despite the Secretary of State's best efforts to remove him. His removal was halted by pesky activist lawyers. Now, let me take you to Mr. M's third country certification. Slightly dense text there for a slide, but I hope you can read it. So Ben's already shown you that the transitional regulations the exit regs only apply to requests to the United Kingdom. The indication from the Home Office, remember Mr. Heppel, is that they will not have the power to transfer under Dublin after 31st of December. And I think that has to be right. And here's why. If we look at this third country certification, decision was made with reference to 345E, which is the Dublin rule. That won't apply after transition. Germany's acceptance was under the provisions of the Dublin III regulation. It's clear it's in terms that its acceptance is under those provisions. The power to remove him as well, if you look at the last line there, the power to remove him under the 1971 Act, power to remove him is dependent upon there being reason to believe he would be admitted. Well, could the Secretary of State make a new decision under Immigration Rule 345 AC by reference to Immigration Rule 345B and declare his asylum application admissible on the basis that Germany accepted him in July? That would depend on Germany's acceptance enduring after the end of transition. And I don't think this is a realistic possibility. I don't think that Germany would be obliged or even able to accept him when the UK is no longer a member state. There's no indication either that the Home Office officials are intending to take this position. And you might have seen this morning, there was a message on RLG sharing an extract from disclosure from this month, that these cases are dropping out of the third country process because the UK is no longer a signatory. I think this has to be the case because even though plainly the Dublin regulation doesn't anticipate the scenario of being a member state at the time of request, but not at the time of transfer, Germany accepted responsibility under the provisions of Dublin III. And Dublin III isn't just the hierarchy and the consequent responsibility in Article 18, but it's also, let's look at recital 22. Sorry, this is just in my notes. I will add them to the slides. These are, I've developed these thoughts this morning. Recital 22 recalls that solidarity is a pivotal element in the common European asylum system, and it goes hand in hand with mutual trust. And of course, the regulation imposes obligations on the transferring member states as well as the receiving states. For example, Article 26 imposes a notification obligation. Articles 4 and 5 are the right to information. Articles 31 and 32 require the transferring member state to give Germany information necessary to ensure the person being transferred receives adequate health care, to protect their vital interest and safeguard their needs, and that's to ensure that vulnerable people are safeguarded during transfer. I think that an acceptance while the UK was a member state does not endure to transfer when the UK is not a member state. I think that the UK could not seek to enforce Article 18 obligation when the rest of the regulations doesn't apply. And also practically, if Germany refuses, where will the UK go to enforce their legal remedy? And let's recall solidarity and mutual trust. If things were reversed and Mr. M were in Germany, having made a previous claim in the United Kingdom, and Germany sought to transfer him to the United Kingdom, the transitional provisions would not apply to him. UK has not included Article 13 of Dublin III in the transitional regulations. Depending on timing, there is an argument that Germany's responsibilities might have ceased. I think that's Article 19, which is one of my forthcoming slides. But to be frank, I don't think we even get to cessation of responsibilities. So for all of these reasons, my view is, unless on an individual basis, Germany's acceptance is sought and obtained, Mr. M's case will come out of the third country system. And so practically, if you've not got removal directions by Boxing Day, write seeking confirmation that your client's case will be dropped out of the third country process and will be considered in country. My advice would be that if the UK was seeking to transfer Mr. M in 2021, reliant on this July acceptance, without a new acceptance, this would be subject to challenge for the reasons set out above. What about someone who isn't what we might think of as a transitional case? So someone whose arrival in the United Kingdom is wholly after the end of the transitional period. Well, let's take the facts of Mrs. N.A., who was the subject of the Court of Appeal litigation in N.A. Sudan. She was a refugee in Italy, and she'd been subjected to Article 3 ill treatment in Italy, including street homelessness and sexual assault. She did have refugee status. What happens if she arrives in the United Kingdom in February 2021? Well, likely Italy would accept her return. So we'd look at, she's a refugee of that country. She might even have a 1951 convention travel document. Rule 345A little 1, this is the Dublin one. And of course, this will no longer apply after the end of transition. Rule 345A, like I said, the Dublin one, doesn't formally require the member state of proposed removal to agree to admit the claimant. And this contrasts with the post transition provisions under 345B and 345C, which both explicitly require the claimant to be admissible to the third country. And so without agreement for admissible, we could have a claimant being unable to obtain protection in the UK and unable to re-avail themselves of protection in the member state. The policy that I've taken you to before provides that these circumstances, without an agreement for admission, that's an unacceptable position to put them in. Now, of course, treating an asylum claim as inadmissible does not remove the need to address any human rights grounds, such as Article 3, based on reception conditions. I'd just also flag that there are no deadlines to admissibility action under the immigration rules. We all know that the Home Office has not enjoyed having strict deadlines for consideration of case placed upon them. And as the Dublin regulation imposed strict timelines. However, the Home Office policy does say that it's important that admissibility action is undertaken promptly in appropriate cases to maximise removal prospects. The longer it takes to action an inadmissibility decision, the less likely it is that the third country will accept responsibility for an individual. And although there are no policy deadlines in respect of inadmissibility decisions, specific time limits may be applied by third countries. So those are the things we'd have to think of if Mrs. N.A. was your client in February 2021. My final example is the case study of Mr. S., an Iranian national who spent several months in Calais before coming to the US. He claimed asylum in France, but even if he didn't, if we could see the next slide, remind ourselves of Rule 345B. Rule 345B could apply to him if he could have made an application for asylum in France, but this will depend upon readmission agreements with France. And certainly there is no blanket EU-wide readmission agreement that was rejected. And so we're looking at individual agreements. And as the Home Office's policy says, case-by-case consideration. So that's all I'm going to discuss for now. There are obviously third country charter flights coming for the rest of the year, but that looks for now that there is a limited period for the wholesale readmission of third country asylum seekers to EU member states from the UK without specific case-by-case consideration. So over to Ben for his for final part of our talk. He's going to be talking about options for transfers to the UK. Thanks.
Okay, so as Harriet explained, I'm not going to cover what happens if you have a client come to you after the new year. So it's a new case, and they have, so say you're approached by a former asylum client of yours in the UK, and their brother, nephew, cousin has just arrived in Europe, and they're looking for ways to get them to the UK to be reunited with them. All the different classes of cases that previously we could have sought transfer under Dublin 3. Now, broadly, the position as I understand it is that unless something changes, because something could change, the UK is continuing to seek bilateral agreements and agreements with the EU on this. But as things stand, in cases coming after the new year, there are three main options as I see it. I'm thinking whether actually there should be a fourth listed on here, and I'll talk about that as I go. So the first category that I'll cover in brief detail today is family reunion under the immigration rules for pre-flight partners and children. So if you have a refugee who came here and had to leave behind their spouse, their child, then that's a route for them to come to the UK, whether it's from Europe or anywhere else. Secondly, entry clearance, again, under the immigration rules, for a child relative of a person with limited leave as a refugee or as a person with HP. Again, that's a route under the rules. Thirdly, entry clearance outside of the rules under Article 8 of the European Convention on Human Rights. The fourth one that I'm wondering about as I go along, which clearly will be relevant, is the adult dependent relative route. And it's likely that that's going to present an obstacle rather than a route in a lot of these cases, I would expect, although I'd be interested to know the thoughts of others on this. So in the panel discussion, Nina flagged the very helpful British Red Cross policy briefing. I've given the link there in the slides. I would recommend having a look at that. It's got a very useful table, as Nina mentioned, of the different classes of case that are currently covered by Dublin and the extent to which they're now going to be covered by the immigration rules after the new year. The headline message is that many cases currently covered by Dublin aren't going to be covered by the rules, and many of them are going to be subject to more restrictive, more prohibitive requirements after the new year. So it's going to be harder to get people to the UK in these kind of circumstances. So first of all, looking at family reunion for pre-flight partners and children. So these are specific provisions, 352A onwards in Part 11 of the immigration rules, and subject to the evidential requirements, which clearly could cause difficulty in some or many cases. On the face of it, this is a tenable route for many cases of minor children who arrive in Europe or otherwise, or partners who arrive in Europe or otherwise. I've linked to a guide on free movement, which is helpful, and the relevant Home Office policy here in respect of these requirements. The requirements of the rules themselves, there isn't anything that jumps out at me as problematic. As I say, I imagine the issue in more cases is going to be evidence, although obviously, it depends on the case and there may well be difficulties depending on the facts. So the second route, which might assist in a number of cases that were previously covered by Dublin, paragraph 319X onwards of the immigration rules, which covers child relatives of a person in the UK with limited leave as a refugee or as a person with HP. So this could be an uncle who's a refugee here, or an aunt or a cousin, so on and so forth. But there are, under this rule, there are a number of requirements which, in my view, are likely to make a lot of applications difficult, or at least open to refusal. It's a way in which I can see a way for the Secretary of State to refuse a lot of applications looking at the nature of these requirements. And so I've just set out some of the ones that seem to me to be more problematic or more likely to be an issue in this type of application. So firstly, a need to show that there are serious and compelling family or other considerations which make exclusion of the child undesirable, and suitable arrangements being made for the child's care. That just strikes me as being open to Secretary of State abuse, if I can put it that way. Secondly, child must be under 18 and not leading an independent life. And that term, not leading an independent life, you may well be familiar with it from similar applications, because it's a term that crops up elsewhere in the rules. That's defined in paragraph 6 of the immigration rules, and two parts of the test in particular seem to me like they might create a problem for this kind of case, because it needs to be shown that the applicant, the child, is wholly or mainly dependent on their parent, or in this case, the relative, for financial support, and wholly or mainly dependent on the relative for emotional support. It strikes me that there may well be many of the cases that would previously come through under Dublin where those requirements might present a barrier. And then two further, the accommodation requirement, the need to show that the child can and will be accommodated adequately by the relative without recourse to public funds in accommodation which the relative owns or occupies exclusively. And so it isn't hard to imagine that plenty of people in this country would struggle to show this, not least people who have arrived relatively recently, having fled their country and obtained refugee status or humanitarian protection. Likewise, with respect to a maintenance requirement under this rule, that you have to show that the child can and will be maintained adequately by the relative without recourse to public funds. I've also flagged as a query, because I don't, on the face of it, know the answer to this, but reading the rule strictly, it only applies to people who currently have limited leave as a refugee or a person with HP. So if someone has moved on and been granted ILR or British citizenship, it doesn't look to me on the face of it that they would be able to bring their child family member to the UK under this rule. It may well be that there's authority on this point, and I don't suggest that I know the answer to that, but it's something that would have to be looked at in any application under this rule. So then third, I move on to talk about entry clearance outside of the rules, because you'll see immediately from looking at those two routes, there are many different types of case that are not covered by those rules. And so you're having to look outside of them. So the parent who arrives in Europe of a minor child refugee who's made it to the UK, or a post-flight partner or child, the adult child of an adult refugee in the UK, so on and so forth. Perhaps just the last category there is also worth noting. Relatives or family members of people whose protection claims in the UK are still pending, so haven't had them determined previously. Those people could be brought under Dublin, but not under any of these provisions of the rules. And so in these cases, an application can be made for entry clearance outside of the rules, relying on Article 8. And of course, in any application that you were looking at under the rules, you'd be wanting to prepare and advance the case more broadly under Article 8 in case it's refused under the specific provisions of the rules. And because of the range of cases that are involved here and that are sort of the subject of this discussion, it's not possible for me to deal with all of them in this presentation because there are different considerations and difficulties that are going to arise in the different class of case. So what I've just sought to do here is flag a few key considerations as I see it if you're approaching a case like this. So the first is to think about and attempt to establish family life for Article 8 purposes between the person in the UK and the person who's overseas in another member state. I'm sure you'll all know Cogarthus and the authorities on the establishment of family life between adult family members or family members outside of the nuclear family. And so you're looking for evidence of real or committed or effective support, dependency of an emotional, financial or practical character, and if possible, more than normal emotionally ties, whatever that may mean. And so the reason I say this is that there's this very unhelpful existing line of authority in the Court of Appeal arising from entry clearance applications for visits to family members, more distant family members or non-nuclear family members, where the Court of Appeal has held that the Convention doesn't oblige the UK to admit a person to enjoy and develop private life. And so if you can't show family life for Article 8 purposes, I think those authorities may well present an obstacle. And certainly there are immediately you think of arguments for the ways in which this type of case, dealing with the position of refugees and their family members, very often dealing with the best interests of an unaccompanied child, for example, in Europe, ways in which these cases are very different from the ones under consideration in those Court of Appeal authorities. But obviously, first and foremost, you want to avoid having to deal with it at all. And the way to do that is by showing family life for Article 8 purposes. Then, obviously, in every case, it's going to be relevant to look at the Home Office policy. And this is the point at which I've brought in the immigration rules on adult dependent relatives. But looking at it now, that ought to have been an independent route under the rules. I'm sure if any of you have looked at it or have any experience with it, you'll know how difficult it is to get entry clearance under those rules. It's been tempered somewhat by the Court of Appeal case of Britsitz. That's the authority as far as I know it, but it's very difficult to succeed in those cases. And so I think more often than not, it's instead going to be the case that you're trying to bring a family member under Article 8 more broadly, pointing to the dependency that exists between the family member here and the person overseas. And the Home Office is going to be relying on the existence of that route under the rules as one of the reasons that it's not disproportionate to exclude that person from the UK and not grant entry clearance. But so I'd say certainly have a look at that and have a look at any other routes under the rules that might be relied on in that way by the Secretary of State. Then the Secretary of State's, the Home Office's policy on this, on so-called exceptional circumstances, what they call breach of Article 8. There are some narrow examples given in that policy of cases that may lead to grants outside of the rules worth having a look at. One of them is with particulars, it's an adult child who's seeking leave to enter to be with their parents here. The main policy refers on to a more specific policy about exceptional circumstances. Again, we know what that means. And that policy identifies a sort of checklist of considerations that may also be useful as a starting point if you're developing one of these applications. And so as I've been able to analyse it and find, those are the main routes as I see it for trying to get people to the UK who previously would have been eligible or able to be transferred under Dublin. I don't know that I've covered all of them, all of the possible routes or tools that will be available to us, but those are certainly ones as a starting point. And with that concludes our presentation.